everyone. Thank you for joining us today. I'm Jennifer Lowe. I'm the Director of Programs and Strategic Planning at the Supreme Court Historical Society. I'm delighted to welcome you to our virtual platform for today's program with Siobhan Barco for the second of the Society's 2025 lecture series, The Lives of Plaintiffs Post-Court Ruling. Siobhan Barco is a PhD candidate in history at Princeton University, where she has been mentored by Laura Edwards, a longtime friend of the Society. She is the producer and host of the American Society for Legal History's Talking Legal History podcast. She also serves on the Advocacy Committee for the National Association of Women Lawyers. She received her MA from Princeton with distinction. She holds a JD from the University of North Carolina and a BA from Duke University. This fall, she will be a fellow at Harvard Law School. Her thesis is focused on From Press to Power, Legal Publishing, Authority, and the Development of American Law, 1830 to 1930, which is what brings us to Myra Bradwell, the case of Bradwell versus the state of Illinois, and her talk today. We will take questions from the audience, so please share your questions in the Q&A box at the bottom of your Zoom screen. Siobhan, the floor is yours.
Thank you, Jennifer. I'm going to go ahead and share my screen. All right. And thank you again, Jennifer, for the kind introduction. It is such an honor and a pleasure to be here with the Supreme Court Historical Society this afternoon and to talk about what came after Bradwell v. Illinois for its appellant, Myra Bradwell. You may already be familiar with Myra Bradwell from the 1873 Supreme Court case, Bradwell v. Illinois. In that case, the justices upheld an Illinois decision to deny Bradwell a law license because she was a woman. Bradwell v. Illinois is widely cited to understand women's historical position in the polity and is a staple of the constitutional law curriculum to understand American women's history and how the Reconstruction Amendments fit into the story of the women's rights movement. What is less well known is that Myra Bradwell was owner and editor of the newspaper, the Chicago Legal News, and president of the publishing company, the Chicago Legal News Company. By shifting our focus to the legal newspaper instead of the Supreme Court case, this presentation illuminates three main things. Looking at newspapers reveals the narrowness of the history presented in the Supreme Court case and demonstrates a fuller understanding of women's socio-legal position in American history. Looking at the legal news and its influence prompts a reassessment of the key sources of legal authority in the era of the Second Founding. And looking at the news's influence helps us reconsider the narrative trajectory of the battle for women in law. These points are actually connected. The way history has been presented in Bradwell v. Illinois has obscured women's status in the legal profession. And so we have missed the story of the Chicago Legal News and how important legal newspapers were to legal practice in the 19th century and to understanding the history of women's status in the legal profession. In the rapidly modernizing legal landscape of the post-Civil War era, Myra Bradwell's Chicago Legal News, known as The News, was the most widely read legal newspaper in the United States. The paper was found in nearly every law office across the nation and was widely cited in court opinions, including the U.S. Supreme Court. Yet the News's influence has been forgotten because of how the 14th Amendment and its application to women has been framed and interpreted. This framing began with the case Bradwell v. Illinois, when the court narrowly interpreted the Privileges or Immunities Clause of the 14th Amendment, excluding women from 14th Amendment protections. Bradwell v. Illinois was a test of this recently passed Privileges or Immunities Clause, which says, "No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States." Because Myra Bradwell's argument and the court's engagement with that argument in their decision focus on broad federal protections for American citizens, the history presented in the legal arguments also is concentrated at the federal level and looks for general legal principles to apply to all women broadly. Case law and scholarship since the 1870s has focused on the idea of equal rights and the conveyance or denial of rights as a way to understand women's social position in American history and to build the body of American law affecting women. Bradwell v. Illinois, especially Justice Bradley's concurrence, where he claimed that the law of the Creator limited women to the benign offices of wife and mother, is frequently cited in court opinions and in legal scholarship to illustrate that women's status in the 19th century barred them from the world of law and politics. In doing this, we have taken legal arguments to be a description of social reality and lost sight of the fact that women were very much involved in these arenas. The image in this slide summarizing that point is from Quimby, a study aid widely used by law students. Here you see a judge telling Myra Bradwell that, as a married woman, she could not adequately serve clients. Yet, many historians have shown that Justice Bradley's characterization of coverture, the legal fiction that a married woman's legal personhood was subsumed by her husband, does not reflect how the law operated on the ground. Bradwell's newspaper bolsters this point. Compare Bradley's dissent, which takes the legal fiction of man and wife being one person literally, with the reality of Myra Bradwell's ability to contract to do the work of running the Chicago Legal News. In Bradley's 1873 concurrence, he wrote, "The family institution is repugnant to the idea of a woman adopting a distinct and independent career from that of her husband. A married woman is incapable, without her husband's consent, of making contracts which shall be binding on her or him." However, a private act by the Illinois legislature in 1869 had allowed Myra Bradwell to contract in order to run her newspaper. It says, "Myra Bradwell shall be liable for the debts of said company, contracted while she is a stockholder therein, and all stock of said company owned by her, and the earnings thereof shall be her sole and separate property." Here, Bradley is dealing in broad generalities and searching for universal legal principles, when in 19th century America, possibilities were open or closed more locally in a patchwork fashion. Here, the Illinois legislature passed a private act granting Myra Bradwell ownership of the news, and a deep network of legal elites supported the success of the paper, all while she was a married woman. While the case Bradwell fixated on individual rights, women like Myra Bradwell acquired power through their networks and relationships. Historians have shown that in the 19th century, the law of associations in private law and municipal level laws that kept the public peace governed privileges and immunities based on an individual's credit or reputation in a given group, ranging in size from a guild like the legal bar to a town. Civil rights in the 19th century were not the broad federal protections we think of today, but instead protected individual rights to make contracts, buy and sell property, and have standing to sue. In contrast to Illinois' arguments in the Bradwell case, that under the common law, women were uniformly excluded from the work involved in making, applying, and executing the law. In actuality, scholars have shown that individualized legislation, guilds, and social connections determine the ability to hold property, obtain licenses, and gain organizational membership. Interpretations of the case Bradwell, narrowly focusing on the history of federal protection of women's rights, have missed a usable past hidden in the wider and more varied social context that appears with a deeper look at Myra Bradwell's life beyond the famous case. Ironically, the rights-focused legal strategy Bradwell used in her case and helped render culturally dominant through her newspaper has obscured the socio-legal world, even as it was building towards a new legal order in which women too would be able to draw on rights. To underscore that the case Bradwell was aspirational rather than a reflection of social reality, one can look to Judith Ellen Foster, who was a licensed attorney trying cases in Iowa alongside her husband, and was serving as legal advisor to leaders of the burgeoning temperance movement in the same period Bradwell's cases were being litigated. Across the 19th century, women commonly handled legal issues in their local communities and prepared legal research and written legal work. For example, in the early 19th century, Julia Smith, Susanna Wright, and Eliza Lucas Pinckney were known to their neighbors in Connecticut, Pennsylvania, and South Carolina, respectively, as a resource when it came time to draw up wills. Bradwell founded the Chicago Legal News in 1868 after over 10 years studying and working alongside her husband in a shared law office. This was all well before the case Bradwell v. Illinois. In this mode of work and education, Bradwell was emblematic of the many women who, through their access to literate social networks in their local communities, obtained standard 19th century apprenticeship-based legal educations and performed legal work in these communities. Women also became printers through familial apprenticeships and were engaged in the legal printing business from the nation's earliest years. Yet this fluid, localized culture was gradually fading and the profound transformations churning in the postbellum legal landscape. Bradwell recognized that writing and written law were becoming more important as commercial exchanges and social networks spanned wider distances. The images on this slide are from the Duke University Sally Bingham Center's 500 Years of Women's Work exhibit and span the mid-18th century to the early 20th. The slide includes images of women making paper from rags, bookbinding, typesetting, and an advertisement for selling, binding, and publishing an array of books, including law books. So how do lawyers and judges find the information that informs their legal arguments? In the 19th century, it was often in newspapers, not the texts that the legal profession now assumes defined the law then. At the news's advent, Theodore Dwight, dean of New York's Columbia Law School, lauded the new periodical's novel enterprise. It is important to underscore how revolutionary the Chicago Legal News was, primarily because of two factors. First, it was systematically recording nationwide court decisions. And second, it was distributing those decisions across the country on a weekly basis, not even missing a week because of the Great Chicago Fire in 1871. The news, in both its subject matter and its form, served as a powerful mechanism elevating a hegemonic legal culture of written law, consolidation, and systemization, while subsuming an antebellum world of community-based legal orders that had often elevated oral proceedings over written methods. The wide reach and comprehensive nature of the news was crucial to the project of standardization. In the second half of the 19th century, the news was widely consulted and cited throughout the country because, as its editor, Myra Bradwell was adept at distilling legal principles from various legal sources and then collating and disseminating the results as legal news that all legal professionals needed to know. The news not only selected, published, and provided headnotes for cases it deemed important, but it also included opinion pieces, book reviews, form documents, and commentary about the law and the legal profession. Bradwell shaped the law by actively curating the sea of materials lawyers and judges would draw from to conduct their work. Furthermore, the news was pioneering in its aspiration for a national reach, replacing lawyers' reliance on regionally specific papers for the most recent developments in case law. The news addressed a want for a legal publication in the West. After publication of her initial prospectus, interest was so keen that the periodical immediately doubled in size to 8 pages, and the newspaper soon expanded well beyond Illinois. It quickly became the largest law newspaper in America, with the most new original reading matter weekly. The news's size of 8 pages created space to host a wide array of legal intelligence. The first pages of the news hosted a segment entitled The Courts. This section included headnotes and copied opinions of recent new and important court decisions from the territories, state, federal, and local decisions. This first section was followed by an array of articles, opinion pieces, and notices about recent changes to court rules or practice norms. In these segments, Bradwell provided commentary about the conduct of judges, lawyers, and legislators, about recent law publications, and the general state of the legal profession. Readers would also find scattered throughout the paper miscellany such as bar association matters, social affairs involving the bar, lawyer jokes, and general interest news. Public notices and advertisements appeared towards the end of the paper. The News's form as a newspaper allowed it to record decisions and apprise its readers about changes to the law faster than traditional sources of legal information, like treatises or law books, appearing in lawyers' hands every Saturday without fail. At the same time, the News was not designed to be ephemeral, but rather bound and saved. It was released and sold as a compiled volume annually with an index of cases published in the periodical that year. The News's collated, systematized method of disseminating the law stands in stark contrast to the patchwork nature of reporting cases that existed earlier in the 19th century. For example, in a letter Thomas Jefferson wrote to William Johnson in 1822, Jefferson tries to write about the habit of the Supreme Court and can only form his opinion based on what he supposes true from the cases sometimes reported in the newspapers, and others which I casually see. Richard Henry Dana Jr., throughout his law career from the 1840s to 1870s, similarly relied on local newspapers for his legal news. This is a photo of one of Dana's scrapbooks, where he compiled his own clippings from local newspapers. As the century progressed, Dana found value in the curated nationwide view of the law offered by Bradwell. He wrote to Bradwell about how valuable he found her newspaper in his Boston-based practice. I found your numbers so valuable to give me the decisions of the Supreme Court of the United States, earlier than I could get them elsewhere, and of the district and circuit courts of the United States, which I could often find nowhere else. In an 1869 letter to Myra Bradwell, Chicago area politician Thomas Hoyne emphasized Bradwell's noble enterprises in new journalism, contrasting her work to the existing trashy legal journals produced on the East Coast. Bradwell, by inscribing away the Jeffersonian world of informality and replacing it with a legal order governed by formality, made the News a major force catalyzing wider trends in the transformations of American law across the 19th century. Unlike those earlier, patchy, disposable forms of legal newspapers, the News was carefully indexed and organized into bound volumes, presaging the advent of legal digests like the West Publishing Companies, which are still used today. In her emphasis that local law in particular should be written down and preserved, stating once that our friends of the profession will at once see the importance of taking a paper that gives the opinions of our local courts, which are now so often lost to the public. Bradwell indicated an inherent shift from a legal culture governed by specific context to a universalized one. When local cases were decided based on specific community context and the relationships between the individuals involved, there was little need to record much of the proceedings in writing. However, under the logic of a standardized universal law, cases needed to be recorded, analyzed, and incorporated into a library of precedents. The fact that Richard Henry Dana Jr. was reading the Chicago-based newspaper in a major eastern city speaks to the News's broad dissemination. Myra Bradwell's lifetime from 1831 to 1894 and the 19th century American legal profession were unfolding alongside a burgeoning industrial network of streams of communication, like rail and telegram. Letters from judges and lawyers across the country, from Wyoming Territory to Washington, D.C., an array of newspaper articles about the News, and case citations to the News and court decisions across the nation underscore the wide circulation and cultural penetration of Bradwell's written legal information. While there has been an emphasis on New York's role in the history of legal codification and in the history of journalism, studying the News shows that a key story about the collation and systematic dissemination of legal information emanated from the Midwest. For just a few examples of the News's reach in the four cardinal directions and the range of legal topics it covered, to the South in 1874, the Alabama Supreme Court drew on a decision recently reported in the News to make a point about bankruptcy law. To the North in 1874, a Wisconsin Supreme Court case cited the News to support a claim about municipal law. To the East in 1875, the Massachusetts Supreme Judicial Court used the News to support a subtle distinction in tort law And in 1880, the Montana Territory Supreme Court cited the news to clarify a point of civil procedure. The map pictured illustrates the geographical reach of the news across the United States based on references to the Chicago Legal News from 1868 to 1925 in the Harvard Case Law Access Database and in the Case Text Database. The News was the first and most influential in a new style of legal news that focused on timely, comprehensive, and wide-scale circulation of legal cases and commentary. Eventually, other legal newspapers adapted and became more like the News, and others were founded in the News's style as it found success, especially in the 1870s and 1880s. The American Law Review, a Boston-based periodical, began publication in 1866 and focused on articles for a readership of legal academics. However, in 1880, it changed its composition to a format mimicking the News to appeal to a more general legal audience, and increased its frequency of publication in deference to a general wish for more frequent issues and prompter information. Even among these legal newspapers that sprang up in the latter half of the 19th century, the News continued to be the most widely circulated and nationally influential of these legal periodicals. A search again in the Harvard Case Law Access Database shows 482 references to the News in court cases nationwide. The second most cited legal newspaper, the Richmond Record, a Virginia daily newspaper founded in 1878, has only 49 references, about a tenth of the News's appearances in court cases. As you can see in the graph shown here, citations to the News peaked in the 1880s. In an 1884 report on the history and present condition of the newspaper and periodical press, Simon North wrote about how integrated legal newspapers had become to legal practice. The law journals publish promptly and accurately digests of the latest decisions in the courts of all the states, and they have thus become quite as valuable to the profession as the law library. According to the Department of the Interior Census Office report published in 1884, in 1872, there were 23 law journals, and by 1880, that number had almost doubled to 45. In 1884, in aggregate, legal newspapers had a circulation of 55,215 copies per issue. Even as the News's dominance as a source of legal information became more diluted and was eventually surpassed beginning in the late 1880s, the News's cultural legacy has persisted. Because of the News's popularity, Bradwell was an agent of legal change. Through a newspaper, Bradwell was systematizing and nationalizing legal culture. Myra Bradwell's daughter, Bessie Bradwell Helmer, asserted that Myra Bradwell's major motivation for this reformatory work was for the relief and elevation of her sex. In this way, Bradwell was following a common 19th century feminist strategy of attempting to use organization and systematization to create a governing order based upon individual merit and equal rights. If all individuals were assessed equally, these women's rights activists thought capable women would take their place in the upper echelons of society. However, in a twist of tragic irony, Bradwell was skillfully advocating for a legal order that would ultimately exclude women. As legal power became more consolidated into formalized written forms and standardizing institutions like bar associations and law schools held sway, the fluid legal world that facilitated her entry into the legal profession was being eroded. Her story adds to the breadth of historical work that has shown that power can diminish even as rights ascend. Increasingly, women, including Bradwell's daughter, Bessie Bradwell Helmer, who was an early leader of the American Association of University Women, had to fight to be included in a rights-based legal order in those places like law schools, bar associations, and law firms, as their modes of social access disappeared and credentialing and systemization took hold. This slide's picture is a diagram of the 1913 Women's Suffrage March on Washington, led by labor lawyer Inez Milholland on a white horse. And it included a contingent of marching women lawyers who were all demanding the right to vote. It's crucial to look at legal newspapers, not just for women's history, but because it gives a more accurate view of how lawyers were obtaining legal information. And the sources they drew on at the time of the Reconstruction Amendments were being legislated and litigated. Bradwell and her news is comparable to great lawyers and treatise writers like William Blackstone, author of Commentaries on the Laws of England, or James Kent, who authored Commentaries on American Law, and that her newspaper issues were authoritative collections and interpretations of present law. The Chicago Legal News should be understood in tandem with these off-cited legal commentaries and drawn upon to understand how the legal minds of the Second Founding were obtaining their legal information. Myra Bradwell was a leader in the legal profession because of the impact of her newspaper, despite the Supreme Court's decision supporting her exclusion from the vocation. Pivoting the angle from which we view Myra Bradwell's story more fully acknowledges the long history of women as legal practitioners in America and Bradwell's role as a key figure guiding the development of American law. Thank you.
Thank you, Siobhan. We're taking questions from the audience, so if you've got any questions, please drop them into the Q&A box. So, does the loss at the Supreme Court give her some of the fire to pursue legal publishing, do you think?
I think, so she actually started the newspaper before the loss in the Supreme Court. So I don't think the Supreme Court case directly gave her the fire, but you see fire in the newspaper. She published everything from the Illinois Supreme Court's rejection of her petition for a license to the decision of the Supreme Court. And she's able to use the power of the press and the audience that she had to really argue against this denial, that like the great title that you gave me for this talk, the Denied but Not Defeated, because while the courts were denying her, you see that she was able to really use the press to get the word out that I'm not defeated. I'm a voice in the law, and she advocated a lot for other women who were trying to become involved in the legal profession, and really used her newspaper to. You see that almost everything she does with the newspaper tries to support the arguments she was making in her case. So
we've got a couple questions about how was she getting the written opinions from courts around the country in a timely manner and publishing them?
Yeah, so she was incredible at, I talk in my lecture about how she had this really deep network and how important that was to her. So she really cultivated relationships with judges. In Illinois, Sidney Breeze was a justice, and Justice Harlan on the Supreme Court wrote to her and would send her cases. Sometimes it would be a lawyer who, was taking their own notes, or a court reporter taking their own notes, and they would send things to her. So she had a network. She had correspondents in different states who would send her things. And she really tried to build this network of informants, either judges, lawyers, or just people who were paying attention to the law who were sending her things. Yeah.
Right. And was her legal publishing work mentioned in briefs or arguments before the Supreme Court or other courts?
Yeah, that's a great question. And it's actually one of the next things that I want to dig through is really go into the briefs. Yes, it was mentioned. I haven't done as systematic of a study of that as I have with the citations. So that's a great question and where I'm headed next.
That's good to know. So how was the paper circulated? Did you subscribe and it was mailed to you? Was it sold on newsstands? All of the above?
Yeah, so she had subscribers, which is interesting because that's actually a contract. Subscriptions are contracts. So as a married woman, she was forming a contract with the people who subscribed to her newspaper. She was really adept also at building these subscription numbers. When she was first starting out, she would just mail people free copies of the news. And eventually hoped that they would start paying her for it. So as she was showing how valuable this newspaper was, the subscribers kept growing. You could get the news every week as that subscription service. You could also just buy it as a bound volume each year. They also offered a service where you could take in your weekly newspapers and they would bind it for you and turn it into a pretty sort of volume for your law library. And then in addition to the Chicago Legal News, they had this Chicago Legal News Publishing Company. So they would print things like form documents, law books. So there was a larger business surrounding the Chicago Legal News.
Right. What happened to the Chicago Legal News following Bradwell's death?
Yeah, so her husband and James Bradwell and her daughter, Bessie Bradwell Helmer, were involved with the Chicago Legal News. The whole time, Myra Bradwell was really the force, but her daughter and husband were very important supporting figures. There's a really interesting story involving her daughter during the Great Chicago Fire. She actually went into the news company office and saved the subscription book as a 12-year-old and didn't see her family again for days while they were trying to survive this fire. And she eventually went to was called the Union College of Law, now known as Northwestern, became a lawyer, and was very involved in the legal publishing business herself. And Myra Bradwell had a son as well who ran the publishing arm of the Chicago Legal News Company. And yeah, she was very much in partnership with her husband. So the lecture talks about how complicated coverture is. So I emphasize that Myra Bradwell owned the newspaper in her own right, but she did have a very supportive husband, and they were kind of in this endeavor of shaping the law together. He was a judge. They were in this law practice together, and he was actually a very skilled printer himself. Her family actually didn't want her to marry him in the beginning because he had been a journeyman, so he worked with his hands. He was also an immigrant from England, and her family was more descended of heroes of the Revolutionary War. So it was a little bit of a contentious marriage. So he was able to help with that, the printing business and the law, and was very supportive of her. She was a bigger star, I would say, in the law, and he was very supportive of that.
He's an early Marty Ginsburg, obviously.
I've thought that before, yeah.
Were there any federal private laws passed by Congress involving women's issues comparable to the one that Bradwell had?
Yes.
Either in Illinois or elsewhere?
Yes. So this world of private law was extremely common in the 19th century. It faded over time, especially in the late 19th century, as this idea of equality and broader rights became more prevalent. But from the founding, it was very common to just have private acts for everything. And you would say this person owned X, or this person is getting a divorce and they get custody of the children. All of these things would be by private laws. So it would be, if you look up like the statutes of Illinois, they have the public laws and they have the private laws. And they're kind of fun to read. It's almost like you can get into the social lives of people who lived in these areas by looking at them. Yeah.
Thank you. Did Myra Bradwell ever speak publicly about this work and her experiences with the court and elsewhere?
She did. She was part of a women's press association. And so she was not unique in having a newspaper. In fact, there was another woman-run legal newspaper in Chicago contemporaneously with the Chicago Legal News. She so she just spoke at bar association. She was involved with suffrage. She was involved in the Chicago World's Fair. She actually wasn't as involved as she wanted to be because she became very ill with the World Columbian Exposition. But yeah, she did. She was kind of a booster for the press and bar associations and that sort of thing. I do think that she was more of a writer than a public speaker. So most of her voice is in writing, as far as I've seen.
Are there similar legal papers published in England?
Oh, that's interesting. I know that there are people in England who they would call sort of briefless barristers. So these are women or men who had legal training who didn't necessarily practice law. And people have written about people who were writing or using their legal educations in different ways. I don't know of how influential the legal news in particular was. I have written a bit just about women writers who were shaping legislation in the UK. And it's also interesting, sort of this world of legal work I was talking about, where women were commonly working in a law office with often a male relative, say a brother or a husband, or I have read just people in the community who want to support this person. That definitely existed in the UK. Charles Dickens, in one of his stories, The Old Curiosity Shop, has a character who's a woman, like kind of acting this way in a law office. I wouldn't be surprised if there are legal newspapers in the UK. I just can't tell you for sure.
Thank you. So what drew you to working on Myra Bradwell and the Chicago Legal News and legal news in general?
Yeah, so I was fascinated by the power of the written word, and not necessarily newspapers. One of the first things that I was looking at were women who were writing novels in the post-Civil War era and shaping perceptions of the law and kind of building the framework for how law would be interpreted as things were rebuilding post-Civil War. So yeah, the power of news and how you can have someone who's not supposed to have rights or access, and they can be so influential in this kind of written world. And then I just kept finding more and more people, not just women, but people in general who were supposed to not have power, who used newspapers to shape the law and government and could really, really make an impact when they were supposed to not have access to rights.
Perfect. And what was the biggest surprise you found in the archives while you were doing your research?
Ooh, the biggest surprise. I think I was surprised by how important the Chicago Legal News was. So I'd heard of Myra Bradwell as this interesting figure, and everyone was like, "There's this case." I was a law student too. You learn Myra Bradwell in con law. Say, "Oh, women can't be lawyers," and it was cool that she had this newspaper, and it was sort of like, "Oh, this is a fun fact." But as I kept researching, it was incredible how it's not just this kind of nice story, or not nice story, but just like a nice parallel of, oh, can't be a lawyer, but has this newspaper. It's can't be a lawyer, but has this newspaper that actually everyone was reading. And not only that, but she was doing something really new and shaping legal information as we understand it today. I don't think that there would be a Westlaw or LexisNexis without Myra Bradwell's Chicago Legal News and how she changed how people access legal information. So I went from, an obscure novelist to what I would argue is like the architect of how we think of legal information and organize it in the modern era.
Thank you. Did Myra have any connections with Belva Lockwood? Were they in touch?
Yeah, I've been asked this before. I don't have any letters between them that I know of. I'm sure that they were aware of each other, and maybe other people who are at Belleville Lockwood experts know of a deeper connection than I'm aware of. She did move in the circles of suffrage and advocating for women's involvement in the law. So I'm sure they crossed paths. Myra Bradwell is a little bit tricky because she doesn't have that many papers. I've been able to find some that haven't been written about before, but there was the Chicago fire. There was a biographer in the 90s who did some really cool sleuthing and found connections to like the Kellogg family in Michigan and found some letters in an attic there. And found letters between her and Susan B. Anthony, but it's sort of piecemeal, these correspondences. So she was definitely in that orbit with Belleville Lockwood. So.
Great, thank you. We have a recommendation from one of our viewers that there is a Netflix show, The Law According to Lydia Poet, who is the Italy's first female lawyer. And it has 2 seasons on Netflix. And she is struggling through the male-dominated legal world and might be good viewing for any of us who are intrigued by that era. So, that long.
That's awesome. If anyone has suggestions like that, they want to email me after or say it now, that would be awesome. I taught a class in the winter, and all of my pop culture references were a little outdated. I had The Firm and My Cousin Vinny, and I think some of the students maybe would have appreciated if I had some fresher pop culture references.
It's the way of the world. Yes. What's next? You're going to do a deep dive into finding references in briefs, but what else? What's coming next?
Yeah, so not only am I interested in the Chicago legal news, but I'm also interested in this just wider world of the press. So Myra Bradwell was not unique. A lot of times we have these talks about her and it makes her seem like she was exceptional. But she was actually a product of wider trends. So my work now is very focused on her. But I would like to expand out more of these wider trends of just the importance of the legal news. And also, like I mentioned, she wasn't the only woman running a newspaper in Chicago at the time. There were many legally educated women who were using newspapers to shape modern law. I have a lot of things that I'm doing next, but one thing that really interests me is the sort of philosophy of law that she talks about in the news. She really elevates what have been called by some, these people called the laissez-faire capitalist. So when you talk about equality and rights, people have written about, that actually led straight to the Lochner era. So exploring sort of the connection between the women's rights movement and the Lochner era and laissez-faire capitalism is something that interests me as well, and how legal news is entwined with that story.
Well, we look forward to hearing more about that. We don't have any more questions from the audience. Thank you so much for joining us today. We really appreciate the time that you took to join us. We could have continued a little bit longer, but we're out of questions. One lecture remains in our series. Ken Mack will be speaking at the Supreme Court on May 21st on Lloyd Gaines. Registration is open on our website at www.supremecourthistory.org. And next week, our Law Day conversation on civics education and the Society's Supreme Court and My Hometowns initiative goes live on May 1st for Law Day. You can visit our website to view it on May 1st. Finally, a survey will go out later this afternoon to everyone who registered in advance. Your feedback is critical in making these programs as rich and engaging as possible. Thank you for joining us. We are adjourned. Siobhan, thank you so much.